we'll get started. Hello, everyone, and thank you so much for coming to this panel. Thank you to the ABA International Animal Law Committee for hosting today. I'm Stephanie Wilson. I'm speaking to you from the unceded land of the Karkan-speaking Ohlone people, and I have the distinct pleasure of being your moderator today. This panel tackles the modest question of what it can mean for nature to be a rights holder in the modern US legal system. We're living in a time of unprecedented interconnected crises: climate change, mass extinction of non-human animals, economic inequity, famine, and drought. And yet our domestic and international policies to date, even the most progressive ones so far, have fallen far short of meeting these challenges. Our conversation today proposes that different frameworks are necessary to ensure the survival of Earth and her inhabitants. Frameworks that aren't new to humankind, but have not been utilized in the post-colonial world that we currently live in. I'll briefly introduce our speakers. First is Jessica Bloom. She's a partner at Greenfire Law, where she practices in environmental and animal law, among other areas. She was previously the deputy director of the San Francisco Ethics Commission and a senior staff attorney with the Animal Legal Defense Fund. Tony Zell is the chair and president of the Earth Law Center. He served as lead editor for the course book and new book on my wish list, Earth Law, Emerging Ecocentric Law, A Guide for Practitioners. Katarina Huey is the director for Having Kids and director of operations and programs at the Village Exchange Center. She has a master's in social work and has dedicated her career to working with and advocating for children and families. Our final panel is a duo. Max Broad is an advocate at DC Voters for Animals and has previously worked as a field director for Vote Blue and as policy specialist with the National Wildlife Federation. And Michael Swistara is a third-year law and public policy student at the George Washington University. Michael has worked with DC Justice Lab, the Humane Society of the United States, and the Environmental Law Institute. We'll have a Q&A session at the conclusion of these presentations, but feel free to post your questions in the chat box. I'll be keeping a list of those questions during the presentations, and we'll read them to the panelists when we get to that Q&A session. Thank you, and with that, I'll turn it over to Jessica.
Hello, everyone, and good afternoon. Thank you for that wonderful introduction, Stephanie. I'd like to start my presentation with a poem. May we raise children who love the unloved things, the dandelion, the worms and spiderlings, children who sense the rose needs the thorn and run into rain-swept days the same way they turn towards the sun. And when they're grown and someone has to speak for those who have no voice, may they draw upon that wilder bond, those days of tending tender things, and be the ones. It's a poem by Nicolette Souter called The Wilder Child. I wanted to begin this panel with this poem because I think it reflects a natural ethos we all inherently accept at the beginning of our lives as children. But then we age, and as we age, we assimilate into a society, both culturally and socially, that replaced that natural ethos long ago with an ethos of consumption. And long before we could formulate a thought or opinion about how we wanted to live, breathe, and experience this world, we were forced into that ethos. And upon our full assimilation into this society that exists, we justify the exploitation of nature, including the living creatures we once held dear to our hearts. Instead of marveling at the dandelions, we ask whether we should grow them for sale as superfood. We debate whether we should protect species from extinction or eradicate them because they annoy us or cost us money. Instead of trying to understand the importance of worms and spiderlings in an intact, functioning ecosystem, we kill them with pesticides so they don't eat our food. Rather than protect the spirit of wilderness and wild places, we innovate ways to extract resources from it for corporate profit. In October of 2018, the Animal Legal Defense Fund and Seeding Sovereignty, a national nonprofit organization dedicated to the preservation of indigenous rights of nature, together filed a lawsuit designed to force the federal judiciary to recognize a constitutional right to wilderness, thereby righting the wrong of this ethos of consumption. We argue that our natural ethos has always existed in the form of a wilderness heritage that was foundational to the formation of American democracy. And as the only true expression of autonomy, the non-human world has always been the baseline against which our due process rights to be let alone, free from government interference, has always been and must be the measure. We allege that the government failed to protect our public lands from disastrous effects of the climate crisis, and we ask the court to prohibit any further extraction of resources from our public lands. In so doing, the court would stop the intentional and unnecessary destruction of wilderness, while also increasing our chances of fighting climate change, because science has shown us that intact ecosystems, especially old growth forests, are the very best carbon sinks science can offer worldwide. I'm here to tell you how, as a practical matter, we brought this case. I'm also going to discuss how the case could affect animal environmental policy going forward. And I'm going to hand the microphone to my co-panelists, who have so much more to say about their work to affect the meaningful and radical change necessary to protect our wilderness heritage and, to be blunt, liberate all animals, both human and non-human, from the perils of government interaction in the face of the climate crisis. I'll start with standing. To have standing to sue in federal court, we have to show that plaintiffs have suffered an injury in fact that is concrete, particularized, and actual or imminent, that our plaintiff's injury is fairly traceable to the defendant's challenged conduct, and that the injury is likely to be redressed by a favorable court decision. To establish redressability, this is an important prong, the plaintiffs must show that the relief they seek is substantially likely to redress their injuries to some extent and within the court's power to award. Redress does not need to be complete, nor does it need to be guaranteed, but it must be more than speculative. So let me take a quick poll, and unfortunately I won't be able to see you, but answer in your hearts, maybe even raise your hand if it makes you feel better. How many of you recreate in wilderness regularly? How many of you need to experience wilderness in order to feel most like yourself? I know I do. I can't go very long without going to the forest. And how many of you feel so connected to wilderness that without it, your sense of self would suffer? Our plaintiffs understand that connection. Thank you, Tony and Kat. Our plaintiffs include scientists, nature enthusiasts, and wildlife advocates who are no longer able to safely conduct their research or interact with nature due to the catastrophic impacts of climate change. They fear increasingly severe and frequent wildfires. And as a Californian living near the forests, I can safely say that it's not just wilderness recreators who are in fear of their lives these days from wildfires, mudslides, and avalanches. And they cannot meaningfully connect with the nature they need to feel fulfilled due to the disappearing snowpack and edible plants that they once relied upon in order to do their beloved activities. Some of our plaintiffs have fallen victims to flash flooding, all of which have been made worse due to the damage caused to wilderness by climate change. We allege that the government, through its affirmative subsidization of consumptive industries, namely industrial animal agriculture, fossil fuel development, and deforestation on America's public lands, has worsened the climate crisis, which has in turn caused the irreversible degradation of wilderness our plaintiffs need to meaningfully exercise their rights to liberty and autonomy. In other words, without nature, the right to be let alone guaranteed by the First, Fifth, and Ninth Amendments to the United States Constitution is an empty promise. We sued the United States Department of Interior, the Department of Agriculture, the EPA, and the Department of Defense, and we sued them in the District Court of Oregon, the United States District Court for Oregon. As I mentioned previously, we asked the court for remedies designed to prevent or stop the extraction of materials from federal lands. And you'll recall that that remedy that we seek has to be fairly traceable and to our plaintiff's injury and vindicate important interests. So of course we seek declaratory relief that plaintiffs and their members have a fundamental right to privacy and autonomy, and the right to be let alone free from interference in wilderness is a necessary condition to exercising those rights. We ask that the court prohibit the use of federal lands for animal agriculture, and the animal advocates and public lands advocates will know how destructive grazing has been to our public lands. We ask that they ban the logging of old growth forests on federal lands. The court ban fossil fuel extraction, development, and subsidization on federal lands, essentially keep it in the ground. And we asked the court to direct the government to consider the impacts of wilderness to areas in its decision-making processes related to family planning. And Kat will get into that a little bit more later. Ultimately, our litigation seeks recognition of what we refer to in academic literature as the zero baseline model. The ZBM argues that evaluations of political autonomy or self-determination must orient from a baseline of the absence of any form of influence or affect. We call that point zero. In the context of this litigation, plaintiffs are asking the court to recognize wilderness as that baseline for the meaningful expression of our right to be let alone from government, free from government interference. Wilderness as a baseline is protective of all creatures, not just humans. And that's not an accident. Humans could live in a sustainable world with a sustainable atmosphere that may not protect the dandelions or the worms or the elephants and bears. We seek absolute protection of intact ecosystems for the benefit of humans and animals alike. Now, the status of our case is on appeal. The district court dismissed our case for 3 reasons. First, the court held that no one in the United States, not one single person, could possibly allege a concrete and particularized injury under that first prong of the standing analysis as a result of climate change, because climate change injuries are shared by all of us equally. Therefore, any plaintiff would lack standing to sue. There's a case that recently was decided by the Ninth Circuit on appeal, styled Juliana versus the United States, in which the court recognized it's possible for individuals to have standing. So we hope to be able to right that wrong on appeal. The district court also found that remedying the catastrophic impacts of climate change presents a non-justiciable question inappropriate for judicial review. That's a much more difficult hill to climb for us, because they also found that in Juliana, the Ninth Circuit. And third, the district court decided against us on the merits of our case, finding that there is no right to a certain environment. And we will be distinguishing our case from the cases that have made that decision over time, because we do not argue for a right to a certain environment. We argue for a right to protection of wilderness. Our opening brief on appeal is due in May 20th of this year, so we're working furiously on the drafting right now and trying to gather amicus partners to support our litigation, and we hope to have a good outcome. Thank you. Oh, I believe Tony might be next.
I am next. Thank you, Stephanie. And Jessica, I'm really pleased that this is set up pretty well for what I'm going to talk about, because I really wasn't so sure about that with this very diverse and broad panel. So let me put up a PowerPoint if I'm able. And it's this one. And I can share it. And I can go to the first slide and start it. That's not the first slide. That is. All right. I can see Stephanie. Can you raise your hand if you can see the PowerPoint? Yay. Okay, good. So I'm going to spend my 15, maybe 20 minutes here addressing these questions. They will tell a story. And in my 30 plus years of being a business litigator, I've learned that telling stories is a much better way to persuade people than to simply tell them about the evidence. And so these 3 questions are questions I think about a lot. I thought about them here. This is on the Continental Divide near Loveland, Colorado. I thought about them here. This is New York City, sitting on what nature exists in Central Park. And I thought about them for about 2.5 years as the co-editors, my Earth Law colleagues and I researched and wrote and edited and ultimately published this book. And I want to accentuate for this group that the second subtitle, A Guide for Practitioners, is something that was very important to the authors. We wanted this to be a tool for the litigator's toolbox, and as well for policymakers, and as well for law students who are working in clinicals and trying to develop their own practice ambitions. My perspective, as I put this book together, was cast largely by my professional experience as a lawyer. It was more than 30 years. It was as a business litigator. I spent more than 1,000 days on my feet in courts, arguing to judges, justices, and jurors. I spent much more time trying to persuade opposing counsel, and sometimes my own clients, and oftentimes my partners, of what I thought was the better way to proceed. I had very limited practice in environmental law. I worked on behalf of the insurance industry in Superfund cases as the corporate polluters who were strictly liable to clean up the messes that they made sought to shift the cost to their insurer. And for what it's worth, for those interested, in my experience, it was about 50-50. I certainly don't think that the corporate polluters carried their fair share. On the other hand, we live in a world of risk spreading, and that's what insurance is for. My perspective is also shaped by fortuity. And about 5 years ago, I was looking for a book to read on a flight to Cape Town, South Africa. And I found a book on a sale rack. It was called Wild Law, attracted my attention. And I want to digress because Jessica wrote that poem read that poem about the wild child. And there is something in that word, wild, that I think is very attractive to those of us who seek the inspiration of nature. I saw the title of the book was A Manifesto for Earth Justice, and everybody's into Earth justice. I, for one, like a good manifesto. I bought the book. I opened the jacket. It's written by an environmental lawyer in Cape Town, South Africa. Got on the internet. I realized he is the progenitor of Earth law. And a few days later, had a coffee with Cormac Cullinan. He connected me with the Earth Law Center, and I shortly thereafter retired from private practice. So that's where I'm coming from. That's my experience. Now I want to share a little bit about, you'll recall those introductory questions. What do I know? Well, I know a little bit about standing because I wrote that chapter in the book, and I read a lot about it. And in the ALDF case, the Oregon District Court held that because the harm plaintiffs seek to redress is a diffuse global phenomenon that affects every citizen of the world, plaintiffs' harm is not individualized and they lack standing. That case isn't in the book, but I do refer to what is probably the first and foremost case written by our US Supreme Court on standing. It's Marbury versus Madison. And this is what Chief Justice Marshall said. It is emphatically the province and duty, the emphasis is mine, of the judicial department to say what the law is. What's hard for me to understand today is why judges and justices find it so difficult to resolve standing issues in a manner that allows them, that empowers the judicial department to meet its duty to say what the law is. And I understand the separation of powers, and I understand the system of checks and balances, and I understand reasonably well the political question doctrine. What I do not understand is why judges and justices refuse to use the power they have to decide important issues. Moving forward in this effort to establish standing for nature, and as the ALDF argues, the human right to nature, the linchpin may be found, and this may be remarkable to some, in answering the question that Judge Scalia presented in framing the standing issue. And he did this in a law review article in 1983. He described the judicial determination of standing in what he called pedestrian terms as the answer to the very first question that one might rudely ask when one person complains of another person's actions. And that question is, what's it to you? Well, I've got an answer for the Supreme Court, so if I ever have an opportunity to answer it. And that is that when our Supreme Court is ready to accept that the answer is the sustenance of human life, and the Supreme Court apprehends that can be achieved through the legal protection of Earth's being and Earth's systems that support biological life, I think the court will conclude that it is well within its province and its duty to confer standing on nature and to find in the US Constitution a human right to nature. I want to shift to the subject or subjects of Earth law. Earth law may be expressed in constitutional terms. It might be statutory law, common law, customary law. It can appear in treaties and other agreements, both public and private. What we probably all know, however, is that constitutional law is the gold standard. And I certainly encourage the ambitious effort to continue to attack our courts' refusal to accept standing for nature and its refusal to recognize constitutional rights, constitutional human rights to nature. The final point I want to make on standing, 50 years ago, Justices Douglas and Blackmun in the Sierra Club versus Morton case wrote thoughtful and to me extraordinarily persuasive dissenting opinions. 50 years later, despite repeated attempts, there is still not standing for nature. And this raises a question in my mind, why would one reasonably expect the present Supreme Court to overrule this long-standing precedent? And one answer is the changed circumstances. And I will make this analogy, which is tenuous for sure, to corporations and their acquisition of legal subjectivity. Corporations became legal subjects when courts recognized that the political and economic expedience in exercising judicial power over corporations' relationships with other legal subjects was indispensable. And the case in which this was determined involved not only a corporation with no legal standing, but another fictional legal being, Santa Clara County. And the way Chief Justice Waite disposed of the issue of standing for corporations is this. Before oral argument, he stated to the attorneys, the court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny any person within its jurisdiction the equal protection of the laws, applies to corporations. We are all of the opinion that it does, and voila, standing for corporations. I think I have got a few minutes left, so let me turn now to movement lawyering. And this is a subject that Michael and Max will address, and it's also a critical aspect of Earth law. It's addressed in the chapter on the movement in the United States towards rights of nature. And movement lawyering is critical. It provides the opportunity to build social norms. The law is a trailing indicator of social norms. The Obergefell case is a very good example of that. However, once there is law, it will reinforce the social norms. Rights of nature, rights to nature, rights of future generations, those are all norms that are developing, and they're developing very rapidly. And I strongly encourage movement lawyering, and I strongly encourage any law students who might be on this call to engage in your critical programs and develop your lawyering skills. The body of earth, the earth law as we've defined it, and you know, it is with all humility. I know nothing more than anyone else, I don't think, about what the legal system can do to move us toward a sustainable habitat on Earth, sustainable habitat for humans as well as all other beings. But what I do know is that Earth law must be much more effective in the next 50 years than environmental law has been since its inception, its modern inception, in the 1970s with the passing of NEPA and the Clean Air Act and the Clean Water Act and the Endangered Species Act. As Stephanie mentioned, we are in a death spiral. And if this death spiral is to be reversed, we need Earth law to be effective. So, as I may have said before, but I'll repeat it, Earth law is a body of law. It's strategy, it's tactics, it's case law, it's policy making, it's movement lawyering, which tends to protect, stabilize, and restore the functional interdependency of Earth's life and life support systems. Earth law is being developed at the local, bioregional, and global levels. It is much more than the recognition of rights to nature, rights of nature, rights of future generations. One of the fundamental bases of the development of Earth law is the public trust doctrine, a doctrine that originated in the Roman Empire 2 millennia ago. Atmospheric trust litigation, there are hundreds, if not over 1,000 suits now worldwide that argue that sovereigns hold in trust the atmosphere for future generations. That is developed. Those arguments are developed based on the context, on the public trust doctrine. The public trust doctrine is also a critical part of the framework for legal mechanisms for guardianship for nature in New Zealand, India, Colombia, Ecuador, as well as in municipalities in the United States, Pittsburgh, Santa Monica, Grant Township, Pennsylvania. Guardianship arrangements have set up to protect the rights that the local ordinances, or in the case of these other nations, statutes and constitutions provide for nature. Another critical aspect of Earth law is the co-violations. And to a large extent, nature's rights can succeed by following the development of human rights. The co-violation of human rights and nature's rights is a subject of lengthy, we covered over 200 cases in a Earth law publication, and you'll see it there if you wish to look it up. The reason I believe it is so important in the development of Earth law to consider co-violations because land and water defenders are murdered in the interest of development that's supported not only by corporations, but by governments as well. We can prosecute human rights violations where nature's rights are also violated, whether nature's rights are legally recognized or not. At its essence, Earth law will be shaped by a new ecological social contract. And again, in this book, we speak about the bases for forming this new ecological social contract, one that is not simply between human governed and human governments, but in which nature itself is recognized for the rights and the might that nature has, and which must be recognized in any agreement we may have going forward. There are chapters in the book that look at global developments in Earth law. In fact, I think there's 10 of them. And one of the last chapters to be completed was a chapter on the Netherlands. And the reason is because in this case, the state of Netherlands versus the Urgenda Foundation, a court, a nation's highest court in this case, for the very first time recognized that governments have a legal duty to address climate change. Jessica mentioned what the Ninth Circuit did in the Juliana case. The Urgenda case presents a perfect foil for the holding by the Ninth Circuit that dismissed the case on standing grounds, on the political question ground to be more specific. And what the Dutch Supreme Court ruled, and any US federal court has ample precedent to rule this way, this is what they said. It is up to the courts to decide whether the executive and legislative branches of government have remained within the limits of the law by which they are bound. This mandate to the courts to offer legal protection, even against the government, is an essential component of a democratic state under the rule of law. I want to mention two more aspects of Earth law, one of which I expect has a particular appeal to members of the ABA's International Animal Law Committee, and that is recognized in the work of the Non-Human Rights Project. The Non-Human Rights Project has brought habeas corpus suits on behalf of Tommy, Kiko, Leo, and Hercules, all chimpanzees, and on behalf of Happy, an elephant. Habeas corpus was created to protect autonomy, and it was based on the autonomous right to bodily liberty. These chimpanzees and Happy the elephant are autonomous beings. And the crux of the argument is that autonomy is in itself a sufficient, though not a necessary basis for personhood, for legal personhood, and the right to bodily injury under the common law of habeas corpus. That's 900 years of common law. As some of you might know, that the habeas corpus writ is first brought up in the Magna Carta. I think I got a slide. Okay, this is the reason that the work of the NHRP is so important. It is not the sanctity of the writ of habeas corpus, although that certainly is important. What is important is how these arguments are presented in a way which presents to the court, and they've been in New York, in the New York courts. It presents these questions that are at the hearts of rights of nature jurisprudence, questions that will always be asked by any engaged judge or justice. Are legal rights coextensive with the human species? Who and what counts under the law? What is the role of the common law in expanding legal protections? We've certainly heard from the Ninth Circuit and many more that whatever their role may be, they're viewing it as being curtailed by the other political bodies. How should science impact judicial decision-making and policy-making? What principles should guide the assignment of rights? And where should society draw the line when it comes to recognizing other species in the natural world as right bearers? These are the questions that underlie rights of nature jurisprudence. The last aspect of Earth law I'd like to cover is it's a chapter that we entitle Indigenous Legalities. And I pause there because it's very important to understand that indigeneity, we all have some indigeneity, but it all differs. It all developed through cultures. So I want to make sure that when I use the word indigenous, I'm using that word very broadly to refer to all people who are connected with their indigeneity. My home is in Newton, Massachusetts. This is the ancestral and unceded land of the Massachusetts people. in about 300 years ago, some lived on a hill not far from my home that was called Nonantum. And the reason that I say this, and the reason it is important to me, is that the development of Earth law is my commitment to restore their indigenous ways of living in harmony with nature. Indigenous legalities envision law, at least as we've written about it, Indigenous legalities envision law and governance systems that are appropriate for the present, for these emergent conditions of our time, with mutually enhancing relationships. Broadly speaking, they propose a fundamental transformation, as a result of which social and legal institutions will foreground human-Earth interactions. So to sum things up here, as Stephanie observed, we're living in a time of unprecedented, interconnected crises that threaten not only human life, but Earth's planetary boundaries. And some of you might be familiar with this chart. It's been published by the Stockholm Resilience Center. And what it shows as safe operating space is in the green in the center of the target. And as you can see, in some of these planetary boundaries, and this is raw, pure, relatively unchallenged science, we cannot live for many generations anyways, outside of this green boundary. Earth law is a way for lawyers and non-lawyers to understand the many ways that our legal system can, and as an ethical matter, I say must, contribute to the great work of living well in a time of unprecedented global crises. Thank you.
Hi. Hi, everybody. I am following Tony, which I'm going to try my best to do because I am not a lawyer. I am from Denver, Colorado, and I am the director of Having Kids. And I wanted to just say thank you guys so much for having me. And just following on both Jessica's, how she started this about children and the ethos and the future generations that we want to protect. And then listening to Tony and feeling so empowered about how we take humans' rights and nature's rights and then fuel that into what the right of our future generations are, kind of brings me to being able to have a small space on this panel with you all on the smorgasbords of a way that we can all work together, and from law to policy to public opinion. And so where we sit in Having Kids, which Jessica kind of alluded to earlier, which she brought up, is that we are looking at how we can protect those future generations' rights and the interconnectedness that it has in actually being able to address many of these things of environmental degradation, climate change, our diluted democracies, and exacerbated inequalities that we're facing, and with children's well-being and safety being at the core value. And that's a core value for me. While I have spent a lot of time in a courtroom working in the foster care system. And for me, my place there was always advocating on the rights of children and where they stood and how we thought about those. So very different. And we'll try to hold my own here. But in thinking of Having Kids, we're a collective group of passionate advocates. And we are thinking about sustainable family practice, and by forming an interpretation of what that looks like to address the unsustainable and misguided practices of our current family model. And we call this the isolation model. And we have written a paper, and it really dictates that the isolation model is universally problematic. And in the 1994 UN International Conference on Population and Development, they recognized the basic right of all couples and individuals to decide freely and responsibly the number, spacing, and time of their children. While we aim to protect the right of the process of having children, we in turn, we believe, limiting our right and cementing ourselves in a problematic subjective parental choice that's short-sighted and reactive. And by that, we're saying that while we are thinking in the case of to having kids or not having kids, we don't actually put the child's right above the wants of a parent. And so when we think about that, we go back and we really, go to Mill and thinking to bring a child into existence without the fair prospect of being able not only to provide food for its body, but instruction and training for its mind is a moral crime, both against the unfortunate offspring and against society. And with the mounting environmental and social threats that are exacerbated by this isolation model, this subjective parental choice that lives in a silo, we are trying to orient that. And for me, that really comes in that we need to move towards establishing a minimum level of well-being, especially coming from the foster care system. I think that's something that we take for granted, and we hear that every parent is going to want a child and want the best for them, but do we ever ask, what does that look like, and how do we create a system that incentivizes us protecting that minimum well-being? And that's where I hope you guys will all come in place. While we're working on a public opinion of changing a social norm that is concreted in a thinking that is protective is actually limiting. So while, and this is kind of oriented to why I'm here on the panel today, is that for having kids, we do believe that the most effective environmental protection possible is having one fewer child. I'm sure you guys have heard that. Having one fewer child has the greatest potential to reducing personal carbon emissions that can protect our environment, our animals, and our children's future. Jessica mentioned the zero baseline, and we also have a form of that in the fundamental values of the Fair Start model, which is reorienting on the child's needs rather than the parent's want. And the first one is improve continuity. And by that, we mean that if generations before us had said that they wanted us to have access to clean water, fresh air, be able to see the animals that they enjoyed having in their life, they would have put those protective factors in place earlier, right? And so we are now having to go back and say, we need improved continuity, and we need to put that in place and say, these are the things that we want for future generations. How do we protect those? So that is incorporated into the Fair Start model. We also find that, in turn, when we're guaranteeing families and children the right to a fair start in life, parents will then move towards having smaller, sustainable families that put less demand on shared resources and our non-human world. And the increased investment of that benefit and to our overall well-being, we believe will reduce inequality by protecting those well-beings and guaranteeing these minimums. It will confront climate change and animal impact because we'll be using less resources in the long run, and we'll be thinking about those protections that we want to put in place. And then we will also be preventing child abuse and neglect. And that's one for me that with 50% of pregnancies unplanned, there's still a lot of work to do here in ensuring that people have access to the reproductive health that they need and the education. And so I also think that we could take time to delay birth, and parents will be more fit for when their children are here emotionally, mentally, and in a place to raise these kids and thinking about what their needs are. So, and then the last is strengthening human rights and democracy, right? And for me, this is a math game. The more people that we have, the more dilution of democracy we'll have, right? And, I'm not going to tell you guys, House of Representatives needs to balloon to like 6,000 people for us to have true representation. So what is the solution? Do we keep adding to an unsustainable model, or do we try to reduce our population? And in that, we can also reduce carbon emissions. So we're looking at the Fair Start model to really be a new model that we orient the cluster of human rights evolved in family planning around the core right of every child's ability to have equality. And orienting that core right in ways answers the critical question that the isolation model that we currently have ignores. And we promote the values of the building blocks to what is truly a human freedom, a human rights to nature and to future generations of this nature and democracy that is interconnected in what we're all talking about today. So I will add a link to having kids, because I want you guys to think about how you can be part of the incentives of policy around if it's baby bonds, if it's how we are addressing court cases around child abuse right now and limiting the actions of parents to protect these future children. And dig deeper into our model. Tell us what you like, what we can be doing better. We're going on the road. We're talking to parents. We're getting this out there. And it's only through the intersection and collaboration of us all that we can get this on, for us here in Colorado, which I'm so lucky to be here and connected with such a beautiful area of nature, is something that we're proposing here in our amendment to increase those protections right here. So yeah, I will drop the link for you guys, and I hope that you will check out Having Kids. Thank you so much, everyone. And I'll be turning that over to Max and Michael.
All right. Thank you so much, Kat. Hopefully you can hear me all right. Thank you so much to the organizers, other panelists, to Stephanie, our amazing moderator, for inviting me and for getting to be a part of this. As Stephanie said at the outset, my name is Michael Swistera. I'm a law and public policy student at George Washington, and I work primarily on animal law and how that intersects with other social justice movements. Max and I are going to be speaking briefly about the land that's currently known as Washington, D.C. And so we wanted to, at the outset, briefly acknowledge that this is the occupied stolen land of the Piscataway, the Anacostan, and the Nacotchek peoples. Broadly, we're going to be speaking for the next 15 or 20 minutes before time for questions about the state of the rights of and to nature here in the district and what it would look like going forwards for DC to incorporate rights of and to nature as a basis for policymaking. So why DC, beyond the fact that Max and I are based here? DC is in many ways in a very unique position. A lot of the sort of authorities that a state legislature might have are vested in a 13-member council in DC. That makes it smaller, nimbler. The district has a large big D Democratic lean as well and makes it a bit more progressive than other state legislatures. And that's demonstrated in the progress that DC's already made on climate issues. We lead the nation in LEED certified construction. The DC Clean Energy Act is one of the most progressive in the country, and the fact that it has DC on course for 100% renewable energy by 2032, net zero carbon emissions or greenhouse gas emissions by 2050. But that being said, there's still progress to be made, which we're going to talk about. And as Kat alluded to, democratic concerns, we need to also acknowledge the drawbacks from DC not being a state, and that table stakes in this kind of conversation about local rights of and to nature really need to begin with statehood for DC, for the climate in the area internationally, but also for the rights of people in our nation's capital. So I'm going to toss it to Max for a little bit to speak about state of rights of and to nature and future concerns.
Awesome. Thanks, Michael. Thanks, everybody. Really glad to be here. So my name is Max Broad. I'm with DC Voters for Animals. We talked about several different angles. I'm coming at this from the advocacy lens, right? How do we implement and promote the changes to public policy and to society that we want to see in observance with our vision for the rights of and to nature. And so a little bit about DC Voters for Animals. We're a local level animal advocacy organization. We work to lift up the policies and politicians doing most for our animals. And that's for all animals, whether companion animals like our dogs and cats, wildlife, or animals in farms or laboratories. So last year we struck our first big victory in a collaboration with several great organizations. The Humane Society had championed a bill in DC Council to ban the sale of ivory and rhino horn. And thanks to a collaboration of many different organizations, we were able to help get that bill passed. And so, DC had been a major market for these products that contribute not only to wildlife trafficking, but to the killing of the park rangers in places where they are protecting these animals. So really a horrendous trade, and really glad to see that DC has left its mark as not participating in the wildlife killing and poaching. So that is really cool. Now I'm gonna share a little bit about starting with rights to nature. In DC, the conversation about the right to nature, it relates to green spaces and outdoors and access, but many people in DC see the right to nature not just as that, but the right to elements that are critical to our comfort and survival. We're talking about clean air, clean water, things like that. And so when we see climate impacts in DC, they are infringing on our right to nature, as we see, increased fossil fuel emissions and increased carbon pollution in the atmosphere, and having discrete impacts on DC that I want to share with you. And they're especially borne by low income and people of color in the district. So I'm gonna just give you a little overview of that. And to do so, I'm gonna share my screen here. The story really starts with DC's income map. So you can see this map from the DC Policy Center. And the story of DC is really, if you look at the east side of the city, the red parts, the orange, the yellow, that's the more low income side of the city. And of course, this is really important for how climate impacts play out. Of course, we'd like to say people of color and marginalized communities are hit first and worst when it comes to climate change, right? So they're disproportionate impacts. And so, and to demonstrate that, I'm going to show you a couple of resources. So first off, we look at sea level rise. And with flooding in DC, there are a couple of ways that we see increased flooding. And I want you to kind of pay attention to the communities living along the river, and then the government buildings, as we see this great tool from the National Oceanic and Atmospheric Administration demonstrating how sea level rise increases, or where the flooding is expected. And you can kind of see, as flooding increases, how the Anacostia River in particular has more and more flooding around the river, and then the government buildings around the mall. So that's one aspect. And then the other aspect I want to show you all is the heat island effect. And some things that are really important about heat and climate change. It's dangerously hot days are more than a health risk, they're actually a mortality risk. So as summers get hotter, it's going to cause more people to get sick and more people to die. And vulnerable groups are adults over 65 and also children, and those with underlying health conditions like diabetes, cardiovascular disease, and folks just in poor health. But also demographically, folks who live below the poverty line, those with lower levels of education, those without health insurance, non-white populations, all are folks who are more vulnerable to heat-related morbidity and mortality. And so, that's where I want to show you the outlook of urban heat island effect. So as the days get hotter, or as climate change causes hotter days, it also causes more heat to come from the city, but also, there are parts of the city that have less green space. And so you can see, here's our DC with Rock Creek Park and a little bit of a park here. But you can see, again, looking on the east side of DC, that's really where a lot of the heat is. And so, there's less tree coverage to help deflect some of the solar radiation during climate impacts. So, we can see, again, we got this tale of two cities dynamic. And, of course, you should know that neighborhoods in Northeast DC see as much as a 17-degree temperature increase due to inequitable planning, such as a lack of tree cover, and a big intersection between racial justice and climate change is redlining. So you know that the neighborhoods that were designed with the systematic denial, I'm defining redlining here, the systematic denial of various services or goods, especially around housing, by federal government agencies, local governments, or the private sector, either directly or through selective raising of prices or offering of loans. Redlining, neighborhoods built on redlining are an average 5 degrees Fahrenheit hotter. So, you know, in terms of the rights to nature, this is where, you know, climate change not only impacts all of us, but it impacts people of color more directly. And, you know, as they say in the climate movement, people of color, marginalized communities first and worst. So that's a little bit about the rights to nature. Now, pivoting here to a specific right of nature topic in DC, you know, an issue that has come up is the caring for our big green space in DC, the Rock Creek Park. And for a lot of people, viewing the animals of the park, the wildlife, the local fauna, is a big element of, you know, how we appreciate nature. But we have to look at it outside of a anthropocentric lens of, you know, do we care about nature only when, or do we assign rights only when we care about nature? Or do they have inherent rights? And so I'm going to be talking about the deers of Rock Creek Park, which the Park Service has been managing. And, you know, when I say deers, I am using the term plural because because language matters. And, you know, there's thinking that when we speak about species like deers in the singular, when we're referring to a plural, it dehumanizes them, or it gives them less validity to their livelihood. And so I'm going to be saying the grammatically correct deers. I hope English majors can hang in with me. And you know, what's been alarming is that we've seen state-sponsored killing of deers in the park. So because we have much of our land in DC is managed by the National Park Service, the federal government has decided that they are going to manage land by killing deers. And, you know, what they're doing is pursuing an admirable goal of restoring park vegetation. But, you know, what's been disappointing is they're using guns as a population management strategy when there are alternatives. You know, we've seen lately the development of immunovaccinations. I'm going to say that word again, immunovaccinations. So those are vaccines that can render deers infertile. And that's an opportunity for the Park Service to achieve their goals in a non-violent fashion. You know, the Humane Society, dating back, even offered to cover half of the cost for the vaccination process. So, you know, this really was something that was worth exploring, and we haven't seen. You know, instead, every year the Park Service goes out and kills a bunch of deer, and the, you know, organizations like Humane Society, Save the Rock Creek Park Deer, and the Animal Welfare Institute have been engaged in this conversation for a long time. And at DC Voters for Animals, we recently got involved to help recognize the rights of local fauna. You know, of course, we all want a park that's well managed and maintained, but its ecosystem is out of balance due to human intervention in the first place. So, you know, we're still learning a lot about immunovaccinations and their viability. But the fact of the matter is, if we can correct the balance of the ecosystem in the park while observing the rights of nature, we can advance a culture of nonviolence that will have ripple effects beyond our dear friends in the park.
Thank you, Max, for that. I'm going to try and speak very briefly about what it would look like for DC to use these rights of and to nature as an ethos for policymaking, and then we'll get to all of your questions. I think a good place to start for this is just a quick value grounding. Kat Houghton of Community Roots and many others have spoken about their experience at Standing Rock as realizing that it was a conflict between two worldviews, one that placed, as Tony spoke about earlier, the interests of capital and for-profit enterprises at the forefront, and another that centered the rights to nature and the rights to clean water and to a clean environment. So in pursuing that second worldview, I think a good place to start would be to borrow the Community Environmental Legal Defense Fund's model of a right to a clean environment bill for DC. That would manifest itself hopefully in ancillary climate policies and people policies, rights of and rights to nature. I mentioned earlier that DC leads the nation in LEED certified construction. That's great, but the DC Department of Energy and the Environment still cites our buildings in the city and in the district as far and away our largest contributor to greenhouse gas emissions. So part of this right of nature needs to be acknowledging global climate concerns with local impacts, investment in what kind of new buildings are we building, how are we retrofitting old buildings to reduce carbon emissions here in the district. Another huge part of that is going to be investment in our district public transportation system to make sure that we have green and accessible public transit for everyone. Before the pandemic, and I know it's changed a little bit since then, but as many as 3 in 5 DC commuters drove by themselves in a car, and less than a quarter used public transit, and an even smaller share carpooled or biked to work. Looking a little bit more locally, a huge part of this is going to be rewilding parts of DC and developing more urban green space. Max spoke about how that's inequitably distributed and the heat island effect in places where we have less tree coverage, less green space. To use a brief example of managed urban green space, the District Department of Parks and Rec manages a dozen dog parks in DC, 9 or 10 of which are in Northwest DC, not a single one of which is east of the river in Wards 7 and 8, which, as Max said, are the poorer parts of the city, the most climate vulnerable parts of the city, the most over-policed parts of the city, and have the most communities of color in the city. So when we're talking about where we're going to site green space, whether that's rewilding or managed urban green space, we need to talk about where we're citing it, but also who is making that decision of where it's cited and what does safety look like in those spaces. Tony also spoke about movement lawyering, and that means taking a lead from the communities that are impacted. So who's determining where these spaces are being placed? And like I said, safety in those spaces. We know that race, socioeconomic status, housing status impact policing and safety in public spaces. Moving on to the intersection of sort of people and rights of and to nature, we know globally that investing in education, particularly for women and girls, is not only the right thing to do from a justice perspective, but is also one of the most effective policies at lowering carbon emissions. And that's no different in DC. We need a local significant investment in education, in reducing the education gap between race and socioeconomic statuses across the district. And we need an expansion of healthcare for all residents of DC as well. And as Kat spoke about, that includes family planning as well. Part of this is reducing wealth and racial inequality. And again, Kat spoke about baby bonds, and Senator Cory Booker's plan is a good one. DC should be able to implement that at the local level to ensure a socioeconomic fair start for residents of DC. Evanston, Illinois recently implemented the nation's first housing racial reparations plan. I think DC can do something even bolder, that it spends more money on more people to help reduce that. It's worth noting that DC, of the 50 states plus DC, which is not a state, we have the worst inequality in terms of wealth inequality in the country. So that's something we need to tackle if we want to worry about people's ability to enjoy and retreat to nature. So taken together, these climate, these people policies, they're going to work hopefully to refocus urban policy on preserving a symbiotic relationship between human and non-human animals, and to ensure that fair start for all people to enshrine a right to nature and to prevent exploitation of the natural world. Just to wrap things up, the rights of nature to flourish is interlinked with the right to continually enjoy and be able to retreat to nature. As Jessica spoke about at the very beginning, we can't retreat to a nature that we've destroyed. Here at the local level, this is going to require bold new thinking that reemphasizes putting people and nature at the forefront and putting them first through understanding the needs that we share and the fact that our future is bound up in how we respond to the climate crisis. As we do so, we can do so equitably, and we need to make sure we do so fairly. We can think globally and act locally in terms of policy innovations, in terms of having a real world impact on the ground. And I think DC would be a great place to start. Thank you all. And if Max, you want to add anything else, feel free, but if not, I will toss it back to Stephanie.
That's great. No, thanks to be with y'all.
Well, thank you. Thank you all so much for this, broad ranging discussion from, this is what we need to address problems, that we need to be addressing them at the interpersonal, the local, the ecological, the state and non-state, the national and international levels. And so just want to popcorn something back to Kat. I think the fact that you didn't go to law school makes you the smartest person on this panel. So I did receive 3 questions during the panels. I encourage everyone to use the raise hands function, and I'll enable your mic to speak out your question after we tackle the first 3 that trickled in. But I'll go ahead and get started with the first audience question. I think it is for Kat, but others feel free to jump in as well. The question is, how do policies that promote a smaller and more equitable family how do policies that promote smaller and more equitable families building empathy in children further rights to and of nature?
Hey, so I'll answer a part of this and I'll include Jessica to fill in because she's done a lot of work around this. But for me, I think by supporting sustainable family planning reform, we're extending social justice to future generations. And in doing so, we're extending that to non-humans and their habitat. And so in turn, I believe this all cultivates empathy, while children will strengthen at the most critical time of their development between 0 to 5 that we know is all this brain activity going on. If we can spend more time investing in them and spending time with them and getting them outdoors, that this will in turn build that empathy for them. And then just along that, if we're thinking of changing the course of how we bring children in because of how they impact the resources in the world around them, then parents have already taken a stance themselves of how they want to raise their children. So that's a big part of the Fair Start model, is having parents as well try to figure out how they can change their lifestyle choices and how they can work more communally with their communities to build that empathy around the more than, human world. And Jessica, you want to add to that?
Yeah, I think that's a great answer. The only thing I would add is the practical issue is, if we keep having children at the rates that we're having children in the world today, there won't be nature to protect because we'll have used it all up in order to support ourselves. So, in addition to the idea that smaller and equitable families are a social justice issue and build good citizens and all the excellent points that Kat just made, I would just say, from the more radical environmental ecosystem perspective, it's also necessary.
Anyone else before I move on to the next question? Okay. Next question is, while we're on Jessica, it's mainly for you, but again, all panelists feel free to offer your thoughts. In your view, what countries should the US be looking to for guidance to formalize a rights of nature framework? So for example, if we look at the laws of other countries, India and Bolivia might seem to be leaders, but the picture appears more complicated than that if we take a step back. So for example, Bolivia's government developed a foundational law of Mother Earth framework, but the Bolivian government itself has enabled, if not itself promoted, the violation of that law or framework on many levels. So in this vein, what should advocates be conscious of, even if the rights of nature are being recognized? And I think that question it makes me think of civil rights in our country. Like, just because they exist on paper doesn't mean that they aren't adequately enforced and are not violated. So I'd love to hear your thoughts on that, if there are any other international leaders, or if the US could potentially be a leader in that space.
That's a good question. I've only briefly looked at other countries' laws, and so I don't think I can form a meaningful answer to that question based on my own research. Most of my research has been toward helping on this particular area, is having kids in ALDF. I think it's just having kids actually develop a proposal for a constitutional amendment that would protect the rights of the environment in Colorado. And from what I've seen, you're absolutely right. The enforcement mechanism is the primary issue that I'm seeing, and many states seem to have constitutionally protected rights to the environment, or some fluffy language in there that would suggest the value is protected by the Constitution, but there is no enforcement mechanism, and courts are really reticent to recognize one unless it's built into the actual legislation. And so I've been an enforcer for a long time, and that's always been my position, that we can have the very best laws on the books, but if they can't be enforced, and if there's no enforcement mechanism, then they're absolutely just a statement of policy that people can ignore.
And sort of a connected question just came in. You know, other panelists feel free to jump in, but it's how do we solve the rights of nature implementation gap? I wonder if any of the panelists have further thoughts on that.
I will share a personal viewpoint, and please, this is just my viewpoint. The rights of nature model is become extraordinarily complex and has been the subject of very well-funded attacks on a constitutional level. This is in the US, on a local level. And what's going to work in the US to develop rights of nature, rights to nature, and much more broadly, just ecocentric awareness, in my opinion, is going to happen at the local level. We've got to build these norms. We need to get people outside, and we need to know better how other beings react. The Non-Human Rights Project I mentioned, but there's many other organizations that deal with animal sentience. There's a difference between animal welfare and animal legal beings. And we need to develop this discrete understanding of how critical it is, not just for human life, but put human life on the back burner for a minute and look at the earth as a single ecosystem. We don't know, we do know that links in this chain are constantly being broken with extinctions and deforestation and desertification and the nitrogenation of our oceans. But we can't look at these big problems and expect a simple solution. We just have to look at little solutions and build the local community norms. Once you've got this community norms, then the enforcement will become much more effective because you've got the community behind it. You're not delegating enforcement to a court or any sort of, forest service, or it has to become part of each human being's understanding that all beings around us are critical to our own survival.
Thank you, Tony. There's a quick logistical question is whether how the recording can be accessed. It'll be posted in a few weeks' time to the ABA tips. That's the tort insurance and trial practice section. I think I used to be in it. I can't remember the acronym anymore. On their YouTube channel. We will post a link in the chat. The next question is population control, in quotes, can be harmful in ways that it upholds white supremacy or changes the narrative of the real issues causing climate crisis. It also often focuses on the global South, blaming environmental problems on those with the least power to address them. How do you navigate this narrative in your work and ensure justice is at the forefront?
I'm guessing this question's coming to me, but everybody else feel free to jump in. I would like to first of all state that this is not population control that Having Kids is working on. It is an incentive for people to have smaller families, and we're not saying that people should or shouldn't have children anywhere in our language. And of course, for myself, being a person of a BIPOC community, I am very sensitive to how we talk about having kids and we, especially in our work, do make a notice of how the carbon emissions, and when we say personal carbon emissions, are the highest in developed countries. And so we're not targeting a global South, a Central America, We actually go out of our way to try to make it clear that those are areas that are actually not as consuming as much as we are, and why that this movement does need to start in places like the US, where we are having such a high amount of consumption, which, Jessica's talked about. That ethos of consumption is built into the narrative of who we are here in America. And we have to undo that, and we have to start somewhere. So in no means is this population control. And we hope that we're always being thoughtful and intentional of how we're representing having kids. So thank you for bringing that up. Anybody else want to answer? Fun question.
Yeah, I mean, as a climate advocate, I'll say that whoever asked that question, that's a magnificent question, and I mean, you should be a panelist yourself, because that the way you articulate it, yeah, you're absolutely right. We don't want a conversation about population control to be surfacing in the climate space, right? We want a conversation around resource consumption, as Kat phrases it, to be thinking about who is using the most resources and who are the drivers of climate change. And the folks in developed countries are going to be the ones who have often contributed the least to the problem and will suffer the most from the problem. And so that's where we want to think about how those of us in developed countries can make a big impact on reducing carbon pollution.
And next question is for Tony in response to the habeas corpus discussion. But again, all panelists feel free to respond. It's the questioner's understanding that habeas corpus prohibits the illegal confinement of another being, and that this right has been recognized for animals in places like Argentina in the Cecilia case. Given the destruction of wild habitats by governments, do you think courts might recognize this as a negative form of illegal confinement, such that habeas corpus application could require governments to preserve those natural habitats? So, in a sense, rather than confining the body in a prison or a cage, so to speak, that the negative right of having no free place for the body to be, or the loss of bodily autonomy by loss of habitat, could that be achieved through, I guess, a broadening of our understanding of habeas corpus?
I think so. I mean, it's a very thoughtful question, and my initial response is yes. We could do that. The problem that the advocates, the non-human rights projects, have run into is the courts, as in the ALDF case, as in Juliana, as in so many cases, they say, well, isn't this more appropriate for our legislatures to deal with? If we want, again, to create a negative right or the positive freedom from right to bodily injury or freedom from captivity, why should the courts deal with that as opposed to legislatures? And I come back to the same answer that I did in the standing question, because they can. Because there is common law precedent to support it. And it's just a lily-livered way of dealing with a question when a court says, let the legislature deal with it. I honestly, I think it's a complete derogation of judicial responsibility.
I couldn't agree more with that. It dovetails to a question I had, and I was wondering if the panelists would speak to it. I think there are ways to address this through the three branches of government potentially, and either looking at the federal level or the state or local level. It sounds and I think our panelists have touched on judicial and administrative / executive, the legislative branch options through that way. I mean, we know most of these branches currently in the US are broken, severely broken, particularly by the last 4 years. But I would love to pose a question of which if there was a branch, which branch is the best way to address these questions, both in an ideal, like you can wave a magic wand and let one branch of government deal with it, and then in the sort of practical real world that we live in right now. I think my magic wand answer would be we would, legislate these rights into existence with all of the, private causes of action and all the good things that us public interest lawyers like to see in laws. And I think, but realistically, I don't see any of the branches of government being helpful. Maybe the executive branch with some, like small scale rulemaking, like inching away at it, broadening our interpretation of the protective laws that we do have. But yeah, I'm curious what others think.
So I'll take a quick shot at responding, Stephanie, and it goes to this issue of checks and balances. And shouldn't all of the branches be checking each other and saying, what are you doing about it? And, and when, for example, a judge asks that question about the judicial department, hey, what are you doing about it, legislatures? Well, ask yourself that question. What am I doing about it? And I do think that the courts at this point in the United States are probably going to be more effective than legislatures and agencies in the executive branch. But I just don't see the willpower. I just don't see the intestinal fortitude. I see judges who just want to keep their jobs and find the precedent that supports their way of thinking instead of finding the precedent that supports a better way of thinking.
I think that's right. I think that we could all imagine a beautiful world where the Congress worked, but that's a pipe dream for the next foreseeable future. I don't know what's going to change it, but it's broken.
Yeah, and I don't disagree with that, but I also want to provide a different narrative here. When we talk about our government being broken, which again I don't disagree with, but also that's a narrative that suits special interests, right? When people feel disenfranchised by their government, that's when people check out. And like when in DC, one thing that we're working on with DC Voters for Animals, collaborating with the Humane Rescue Alliance, is the a bill that would give pets or judges the ability to preside over pets in a divorce, and deciding not only who the ownership of the pet is, but also like looking out in the best interest of the pet when deciding who the pet goes to. And that's a nice step towards recognizing the right of the pet, but it's a long ways from it. And the fact of the matter is that the judges, the courts, there's definitely an element of public opinion in their decisions, as is the legislature. So we, from an advocacy standpoint, we need everybody who cares about these issues, whether it's about animals, whether it's about climate change, whether it's about social justice, to be speaking up, to be active, to be contacting our politicians, to be loud, to encourage. You don't have to be mean to move issues forward, but we all have to be vocal, and definitely want to promote that.
Just to chime in really quick, going off what Max said, and thank you for bringing up the pet custody role, Max, because I had some role in that as well. I think Max raises a really great point about the importance, as Tony spoke to, not just of horizontal checks and balances, but vertical, that cities and states are still stepping up and being more responsive in places where the federal government is being derelict of its duty. So I agree with you, Stephanie. I would like to see the federal legislature as sort of the most democratically accountable, hopefully, branch do the most. But I think where they're not at the federal level in our federalist system, states and cities and districts can step up and hopefully take on some of that.
Thank you. I feel so much more inspired now. Thank you. I think, there's a great question again from the audience too. I think round us out. It's given that co-violations of nature's rights and human rights occur, is there an argument to have a single set of rights for the entire Earth community? For example, how Ecuador currently has separate rights holders for nature and for humans, right to a healthy environment?
So I love that question. And the answer is sure, that'd be great. But here's what I want to put in our minds. We're talking about rights, an extremely deeply seated concept of Western law. I'm working, or the Earth Law Center is working on a project. It's called Ocean Kinship. And it used to be called Ocean Rights. But we realized that island nations, particularly in the Pacific, don't want their legal foundations to be grounded on rights. They want it to be grounded on kinship. They want it to be grounded on the interdependency of the human world with the rest of the world. And of course, if we could have universal rights, and there are universal Declaration of the Rights of Mother Earth, for example, which if embodied by all nations of the world and all peoples of the world would provide a solid rights-based foundation for living in harmony with nature. But again, the thought I want to put in our minds is, should we question the fundamental effectiveness of rights-based legal frameworks? I'll take that as a yes.
Thank you. I just want to take this opportunity to thank each and every one of our panelists again, and thank you to Professor Raj Reddy for bringing you all together for this brilliant and insightful presentation. And